Hello everyone, welcome to Legal Darshan. In today's video, we will be starting with the first case out of the 86 leading cases given by Supreme Court for the AOR exam. Today we will be starting with L. Chandra Kumar's judgment. We will be having a look at L. Chandra Kumar, what has been said by the court, by the Supreme Court in L. Chandra Kumar's judgment. Now, we need to know a few things before we move ahead with the merits of the case. Now, this judgment was a seven judge was pronounced by the seven judge bench, and it is taking into picture SP Sampath Kumar. SP Sampath Kumar case. So SP Sampath Kumar case was a five-bench judgment, which is talking of the interaction between the High Court and the tribunal, Central Administrative Tribunal. Since SP Sampath Kumar was a five-judge bench, five-judge bench case. Of course, we needed a larger bench to reconsider the judgment pronounced in SP Sampath Kumar. Now, we are discussing only L. Chandra Kumar here because ultimately L. Chandra Kumar overruled what had been held in the SP Sampath Kumar case. So, in this video, we will be having a glimpse of what SP Sampath Kumar judgment was and how it got overruled, on what merits it got overruled by L. Chandra Kumar versus Union of India and others, right? So, as I was discussing in the previous video that was uploaded regarding the AOR exam, regarding the exam pattern, how we will be covering 86 judgments. I was telling you that it is an open resource paper, which means that you do not have to buy any question papers or to buy any case summaries at all from outside. So everything that we need to do, everything that is required, every resource is available out there. So I'll not again be using any presentations or whiteboard in this in these series, in this video or in this series, because everything is available in the open domain. Okay, so there is uh, DGSCR website. It is having record of all the landmark, all the judgments, all the reportable judgments Supreme Court has delivered till date. Any judgment of Supreme Court, you type it in the search box and DGSCR website will open it for you. Okay, so this is an open resource you may refer while preparing for your AOR exam or any other exam you are preparing for. Okay, now the best thing about this website is it is also providing you the head notes. Okay, so the head notes, a summary, a compilation of what has been decided, what were the facts, basic contentions that were taken by the respondents and the petitioner. Everything has been summarized here in the head note, and of course the judgment is also present here, so you may have a look at it at this. You may go through it and you may download the judgment from here. It is a free resource. So we will have a discussion on SP Sampath Kumar and L. Chandra Kumar today. Now, what is happening in SP Sampath Kumar and L. Chandra Kumar is that Article 323A, 323B, and some provisions of Administrative Tribunal Act. This is Administrative Tribunal Act of 1985 is in question. So the court in this case, in Sampath Kumar as well as L. Chandra Kumar, is examining the constitutional validity of Section 28 of the Administrative Tribunal Act. Okay, so I'll just scroll down to section 28. Now, section 28 here says, we'll first go through Sampath Kumar and then we will go to L. Chandra Kumar to see how the court is reversing its findings. Okay. Now, in section 28, yes, section 28 of the Administrative Tribunals Act. Yeah, it is basically saying it is the barring jurisdiction clause. So it says that administrative tribunal, firstly, we need to understand what an administrative tribunal is. Okay, to understand that, we need to go to the constitution first. Okay, so article 323A article, now you need to comment down, you need to answer that by which amendment article 323A and 323B were inserted in the constitution. So this is your question which you need to answer in the comment box, and you can check your own knowledge, of course. Okay, so article 323A is speaking of administrative tribunals. Now we will quickly go through the provision first, and then it will be easier for us to come to the case law. Now when we talk of administrative tribunal, article 323A is providing parliament the power. Yes, it is providing Parliament the power to provide for adjudication or trial by administrative tribunal of disputes and complaints with respect to recruitment and conditions of services of person appointed to public services and post in connection with the affairs of union or state or any local authority within the territory of India or under the control of government of India or any corporation owned or controlled by the government. So basically, Parliament may provide a platform, may provide a tribunal which adjudicate and try the matters pertaining to public service, employees in public service, or people connected with affairs of government, be it state government, be it union government, be it local authority or any other authority, and any corporation which is owned by the government of India. All right. Now, there is this. So we made an authority, we made a tribunal. Okay. Under Article 323A, we are talking of Parliament can make a can release a law, can make a law, and can construct administrative tribunal. Now, exercising, because it is saying Parliament may by law, which means by lawmaking, we have exercised this power, and in 1985 we created the Administrative Tribunal Act. The Parliament passed the 1985 Administrative Tribunals Act. Okay. Now when we move to clause 2, the main provision that we need to deal with in this case is Article 323A, clause 2, subsection 2, clause D. The clause D is saying that a law made under clause 1, the parliament, with the parliament law made by parliament is making law for a tribunal to adjudicate and try matters relating to public services. The law may exclude the jurisdiction of all courts except the jurisdiction of Supreme Court under Article 136 with respect to dispute or complaints referred to in clause 1. So यहाँ पे एक may clause आ रहा है. It's a discretionary clause saying that parliament जो है वो बार कर सकती है exclusion सारे courts की except the jurisdiction of Supreme Court under Article 136, which is the special leave petition jurisdiction of the Supreme Court. Okay, so this particular clause is in question before the court in the case of L. Chandra Kumar as well as in the Sampath Kumar case. Now, when we come to 323B, we'll just have a glimpse of 323B. So 323B is basically saying 323A ने हमारे public services matter के लिए administrative tribunal constitute कर दिया. 323B कह रहा है कि और भी affairs के लिए, और भी matters के लिए आप tribunal बना सकते हैं. Legislature जो है वो law pass कर सकता है. Now the difference is यहाँ पे लिखा है appropriate legislature. So it can be state legislature and it can be parliament. Now how we will decide state legislature or parliament is a matter of Schedule 7. So the entities which fall in the state list will be will be legislated upon by the state government, and entities which fall in union list will be adjudicated upon would be legislated upon by the parliament. And if the matter is of concurrent list, then both have the power to make laws, and subject to the center state relations, either law will prevail. Okay, so that is why we are using the word appropriate legislature here. But when we talk of Article 323A, which is talking of administrative tribunal, here necessary it is Parliament. So this is one difference you may note when you are studying. Okay. Now let's get moving to 323. 323 is saying the same thing, that you can constitute tribunal. The appropriate legislature can constitute tribunal for any matters. For example, assessment of tax, foreign exchange, labor disputes. We do have labor tribunals, land reforms, rent tribunal, or etc. etc. Many such tribunals for other purposes other than public services. Okay. Now, even in this article, in subsection 3, again, the clause D is saying the same thing: exclusion of the jurisdiction of any other court except the SLP jurisdiction of Supreme Court. 136, SLP jurisdiction of the Supreme Court. Parliament or appropriate legislature may exclude the jurisdiction. Okay. Now, constitution is giving you the permissibility to exclude the jurisdiction. Okay. Now the question here arises that when we come back to the 1985 Act, we are looking at section 28. 28 is saying, on and from the date from which any jurisdiction, powers, and authority becomes exercisable under this Act by a tribunal in relation to recruitment and matters concerning recruitment to any post or service matter concerning member of any services or persons appointed to any service or post, no court except the Supreme Court or any industrial tribunal, labor court, or any other authority constituted under the Industrial Disputes Act 1947 or any other corresponding law for time being in force shall have, no court except these two courts shall have or be entitled to have jurisdiction, powers, or authority in relation to such recruitment of or matters concerning such recruitments or such service matters. Now, an interpretation of section 28 could be that it is also barring the 226, Article 226 writ jurisdiction of HC, writ jurisdiction of high courts. Okay. So now Article 226 and Article 32. We all know that these article empowers High Court and Supreme Court respectively with writ jurisdiction. So Article 226 is for High Courts, Article 32 is for Supreme Court. We read Article 226 alongside Article 227 because Article 227 confers supervisory jurisdiction on the High Court. Now the question here was that when we talk of writ jurisdiction, when we are specifically talking of writ jurisdiction, we are talking of judicial review. So, writ jurisdiction is the applicability of judicial review. Judicial review is the basic concept behind Article 226 and Article 32. So, we are challenging the orders, we are challenging any administrative action that might happen in judicial review. Now, when you bar, here it is written Supreme Court. So when we are writing Supreme Court, we may consider Article 32 and we may consider Article 136, that because it is not mentioning just SLP, just 136. So when we are writing no court except the Supreme Court, we can say that it is also allowing Article 32, but it is not allowing Article 226, the High Court supervisory jurisdiction, right? So here, your judicial review has been barred. In a sense, your High Court's judicial review has been barred. Now, this challenge to Section 28 regarding its constitutional validity was uptaken in Sampath Kumar's case. Okay. So I am opening the Sampath Kumar judgment. Now, Sampath Kumar case is a 5-bench judgment. Okay, so 5 judges are deciding this case. And in Sampath Kumar, I will not take much time on Sampath Kumar. In Sampath Kumar, Section 28 was upheld. It was said, now there are various parameters on which the Supreme Court is assessing how administrative tribunal is interacting with the High Court's jurisdiction. Now here, the courts have configured out that because in tribunals, the persons being appointed to tribunals have the eligibility conditions as similar to the High Court, and even they are retired High Court judges. So we can say that tribunals, the administrative tribunal, exercising as a substitute of the High Court, because it is saying that since High Court, the judiciary is burdened with a lot of matters, it has a lot of matters coming before it. The whole purpose of creating tribunals was to lower the burden of judiciary, and the qualifications of tribunal judges, tribunal chairpersons, and judicial members and High Court judges is more or less same. Retired High Court judges do go to tribunal. The the retired High Court judges, yeah, they do go to tribunal and they sit there. So why not we make tribunal substitute of the High Court? So in this case, it was held that Article 226 jurisdiction will not be applicable here, because 323A 2D is also providing it, and Parliament has legislated in Section 28 of the Administrative Tribunal Act, and therefore the supervisory jurisdiction of the High Court cannot be invoked here, because of the basic purpose, that because of the basic ground that tribunals are not subordinate to High Court, but rather they are substitute to the High Court. Okay, to the High Courts. Okay, therefore it was held that these were not unconstitutional. These provisions were not unconstitutional. Now, the finding of this case is being revisited in the case of L. Chandra Kumar. Now, in L. Chandra Kumar, the Supreme Court is noting that it is not just about subordination, or it is not just about substitution, but it is about one of the integral aspects of Indian legal system, which is judicial review. So in Keshwanand Bharati, the court here is looking at Keshwanand Bharati's judgment, and many other judgments, of course, which is providing that judicial review is an inherent feature. It is an inherent feature of Indian polity, of Indian legal system. And when you bar the 226 jurisdiction of the High Court, Article 226 jurisdiction of the High Court, you are basically violating the basic structure as well. Now, in this case, what the courts held, it is there in the head note. The court held that Article 323A subsection, sorry, Article 323A, Clause 2, Subclause D, and Article 323B, Clause 3, Subclause D. These clauses are unconstitutional to the extent that they bar the writ jurisdiction or the judicial review jurisdiction under Article 226 or Article 32 of the Indian Constitution. So, any provision of the law cannot bar the judicial review, the jurisdiction of Supreme Court or High Court, which exercises judicial review on uh, on its subordinate bodies or on the bodies out there in its jurisdiction. Now, when we talk of Article 227, Article 227 says that all the courts in the territory of a state shall be subordinate to High Court. So there shall be a subordination to the High Court of all the courts in a state. Now, when we look at tribunals, when we look at administrative tribunal, the benches are state-wise. We have New Delhi bench, we have Pune bench, we have Madhya Pradesh bench, Bhopal bench. So the benches are located state-wise, and therefore High Court does have a power to exercise jurisdiction upon it. Now, when SP Sampath Kumar said that the tribunals are not subordinate but substitute to High Courts, the L. Chandra Kumar judgment is overruling the aspect, and it is saying that they are not substitute but rather they are subordinate to High Court, and the judicial review of High Court shall be valid in the cases of tribunal. So when we say that we are barring the jurisdiction of High Court, we are barring the 226 Article 226 jurisdiction of High Court to exercise judicial review, we are basically making a provision unconstitutional. So with this, the court also held in Chandra Kumar case that section 28 of the Administrative Tribunal Act is unconstitutional to the extent unconstitutional to the extent that it bars the judicial review of High Court or Supreme Court, so that it bars the Article 32 or 226 jurisdiction of Supreme Court or High Court, respectively. Okay, so this was the finding in Chandra Kumar with respect to the interplay between High Court and the Administrative Tribunal. Now, another question that was raised in this case was regarding one single member benches in the tribunal, Administrative Tribunal. So it was held that you cannot decide. Uh, we come to Section 5 of this Act. Just let me move the screen. Yes, section here the court also construed one more aspect, which is section 5 is basically talking of the composition. Now, the composition section was also challenged in Chandra Kumar. It was said that to decide the matters relating to public service, relating to service and appointment, Article 309. So basically, Article 309 is saying you that appropriate legislature may regulate the recruitment and conditions of service of person appointed to public services and post in connection with affairs of the union government. Now, Article 309 is giving the power on appropriate legislature to legislate the recruitment, how recruitment will happen, how public service members, the conditions of their employment, etc. Now, it was decided in this case as well that when we read section 5 subsection 2 and when we read subsection 6, it is subsection 6 is saying, notwithstanding anything contained in the foregoing provision of this act, it shall be competent for the chairman or any member authorized by chairman in this behalf to function as a bench consisting of a single member and exercise the jurisdiction, powers, and authority of tribunal in respect of such class of cases or such matter pertaining to such class of cases as the chairman may by general or special order specify. Now, here what is happening is that when we talk of single member bench, okay, now how a tribunal is constituted? A tribunal is constituted by a chairman. There is a chairman of the tribunal, and there are two kinds of person. One is judicial member, and another is administrative member. Now, section 2 clause 6, 5 clause 6 is saying that chairman may constitute a single member bench and refer the matter to it. Now, the member may be administrative and the member may be judicial. So the question here came that if the chairman appoints an administrative member only as a bench, won't that be executive interference in the judiciary? So herein the court is also looking at the doctrine of separation of power. It is striking a balance in this section. It is striking a balance between section 5 clause 2, section 5 subsection 2, and section 5 subsection 6. So it is saying that section 5 subclause 6 is not unconstitutional on the ground of separation of power, because section 5 subclause 6 is coming with a proviso. So here is a proviso in section 5 subclause 6, which is saying, provided that if any stage of hearing it appears to the chairman or such member that case or matter is of such a nature that it ought to be heard by a bench consisting of two members, the case or matter may be transferred by the chairman, or as the case may be referred to him for transfer to such bench as the chairman may deem fit. So the court here is saying that section 5 clause 2, which is saying that each matter shall be put before yeah, here it is. We come to, yes. A bench shall consist of one judicial member and one administrative member, so that each matter is put before both one administrative member and one judicial member. So court is striking a balance here between section 5 clause 2 and section 5 clause 6, saying that we read section 5 clause 2, we are ultimately reading it with section 5 clause 6 proviso, so that there is a harmonious construction. All the matters which are related to article 309, which are related to appointment, recruitment, or conditions of service of public service employees, it shall be referred in accordance with harmonious construction of section 5 clause 2 and proviso of section 5 clause 6. So whenever we talk about section 5 clause 2, adjudication of matters regarding article 309, regarding the recruitment or regarding the conditions of service of public services employees, we automatically invoke the proviso to section 5 section 5 subsection 6, section 5 clause 6, and therefore section 5 clause 6 is not unconstitutional, okay, because we are invoking the proviso, and we are putting that matter before a two-member bench, okay, which is one judicial member and which is one administrative member. All right, so this was it for L. Chandra Kumar's judgment. We will meet again with another judgment in a short while. Please stay tuned with us. Thank you for watching. Have a great day.